welcome to Sakshi, Mana Sakshi. I am Priya Goteti. Welcome to Sakshi TV Special TV Immigration Show with Autonomous Prashanthi Reddy from Law Offices of Prashanthi Reddy PLLC. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email usa@sakshi.com or call 866-725-741. Before we begin the show, please note that the information provided on this show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for use of this information. If you need specific legal advice, please contact the attorney directly. So without any further delay, let's start our show. Hello Prashanthi, how are you and welcome to our show.
Thank you, Priya. I'm good. Thanks for asking.
So Prashanthi, can you please provide updates on your law officer's practice areas and your experience?
Yes. My name is Prashanthi Reddy. I'm an immigration attorney. We practice mainly family-based as well as employment-based immigration. Our offices are in Midtown Manhattan, and you can reach us at www.reddyesq.com. That's our website. I've been doing this for quite some time. It's been 23 years since I've been doing this immigration, specializing in US immigration.
Thanks, Prashanthi. And viewers, today we'll be discussing on the Visa Bulletin and I485 frequently asked questions. So before we get into this topic, you can call us on the numbers on the screen for questions related for immigration and also ask some tips. So Prashanthi, can you please give us updates on the current Visa Bulletin, especially the updates given by Charlie Oppenheim on what to expect regarding visa ability for Indian nationals this fiscal financial year?
Yes, this is a hot topic, a lot of buzz going on about what Charlie said on the 24th, that was the day before yesterday. So there is, for those who don't know, there is on the travel.gov website, Charlie Oppenheim, who's the one that's responsible for the visa bulletins, gives an update, has started giving an update every month on what to expect with reference to the month's visa bulletin after the visa bulletin comes out. So that you can get that on the travel.gov website, or it's called Charlie Speaks, and it's also on YouTube if anybody is interested. But the reason we are discussing it, he has the updates every month, which is very useful. But the reason we decided to discuss it this week, choose it as a topic for this week, is there's a lot of information that he gave us with reference to the June visa bulletin and moving forward. So it was a very informative session and provides insight into, what to expect for the next few months until the end of the year, and what to expect for the next year as well with reference to visa bulletins, especially for Indian nationals. As we all know, Indian nationals, EB1 is current, but EB2 and EB3 are still severely backlogged, but they didn't move. Like we discussed in our last week's bulletin, there was significant movement on EB3 and EB2. So I won't get into that again, but what I wanted to discuss is what might happen moving forward. That's what everybody's always asking. It is like, what do you think will happen? What priority dates do you think will become available? Everybody's very anxious about that, and Charlie did throw some light on that, and I wanted to share that with the viewers. So just to go over the highlights of what he discussed. First, he discussed about how these final action dates are actually determined. What is the process used? We all know it's a very complicated process, so we can't get into that in detail. But just to give you a summary, they will look at how many visa numbers have been used so far. They'll look at how many visa numbers are remaining for this year. As you know, visa numbers are limited, and each country again is limited in the amount of visa numbers it gets. There's only 7% for each country. So India, though it is such a big nation and has so much demand, it's only 7% for India as well. So they will look at the availability. They will look at the visa numbers remaining, and they will look at the overall demand for visa numbers that is, that they think will happen in the near future. So if they think the demand will be low in the future, they'll open up a few visa numbers. They'll open the gates. If they think the demand is high, which means the demand can become high due to many reasons. One is people just filing more cases. Other is USCIS processing cases faster. So whenever USCIS processes a case, a 485, or immigrant petition abroad, and it reaches its final conclusion when all the documents are ready, at that point the officer will ask for a visa number. So if that,
Prashanthi,
yes.
before going into further updates, we have a caller, Kishore from New York. Hi, Kishore. Hello. Hello, Kishore.
Yeah, hi. Good evening. This is Kushal Bhola.
Yeah, Kushal. Yeah, please go ahead.
So my question is basically, I'm on H1B visa. Last year in July, my employer filed for an extension. At the same time, employer also filed for an H4 extension for my wife. My wife had plans to go to school, so she started her school with H4 visa. And then subsequently, we had jumped through the hoops and we went to India and got F1 visa in January 2021. So right now she is on F1 visa. We don't care much about the H4 visa. She has filed for F1 OPT application. So my question is that, is it a problem for an F1 OPT application with USCIS if the H4 extension application, which was filed last year, is still showing as case has been received by USCIS?
So if you file the F1 visa after you file the H4 visa, you don't have to worry about the H4 visa because, last action rule applies. And based on last action rule, whatever case you filed last, that will be the case that USCIS will look into. And that will be the case that determines, your status. So even if your I140, you can always withdraw your I140. There's no need to keep it hanging there. But even if you don't, and your I140 gets approved, your status will not be that of I140. Once the approval comes, it'll still be that of the F1 because that's the case I'm presuming you filed last. If that's correct.
So that is correct. So yes, absolutely. At this point, we don't care about the H4 application. We were under the impression that this would be invalidated or withdrawn by itself. It just so happens that it is still showing as something which is an active application. So what would be your recommendation? Should we go ahead with the withdrawal process? Because the F1 OPT application for my wife seems to be taking longer than what it has been for some of the other peers of hers.
So the fact that you have a H4 pending does not affect your F1 application, but there's no need to have a H4 pending if you're not going to use it. My suggestion is to withdraw. It doesn't automatically get withdrawn as you thought. You have to actively withdraw it in order to, for it to get withdrawn. Otherwise, they'll continue processing it.
Okay. And I believe that is as simple as writing a letter to the USCIS that I don't want this application to be active anymore and I want it to be withdrawn. Is that correct?
Yes, along with the receipt notice.
Along with the receipt notice. Okay. All right. Thank you so much. That was super helpful.
You're welcome.
Yeah, thanks for calling us. So Prashanthi, shall we continue with our updates?
Yes, please. So, where was I now? Yeah. So I think we were talking about how they determine, what the final action date should be. That's based on the demand and supply, and it's based on future demand. So all these things are looked at, and I guess every month Charlie Oppenheim receives an update from USCIS on what their expected demand is for the following month. So based on that, the gates are open, shut, or, open a little bit or closed a little further. So that's how they determine the visa number. So it's not X equals Y. I don't know if they have a formula, but it is based on many factors, not just the number of visa numbers left. You would think that if visa numbers are being used, Y are left, then they should open up all Y. They won't necessarily do that. They'll see what the demand is like. So, it's more than just that. So when actually we discussed about when the numbers are actually allocated. Usually the numbers are allocated, as I said, when the visa officer has or USCIS officer has received all the information required on your 485 to complete the application. For example, if there is a request for medicals on your application and your date is current, then as soon as you send the medicals and the USCIS officer receives it, that's when he will ask for a priority date to be reserved. So once it's reserved, even after that, if the priority date becomes unavailable, you will still get your green card as long as it's reserved. It's taken by the officer. So they have to go on an online and reserve it. There's a process that they follow. So a lot of people wonder when the date becomes, the processing becomes current and when the visa number is actually used up. So that's for all those who don't know, that is, the process. Now we have seen a lot of very aggressive forward movement for EB3 cases, especially for final action date, both EB2 and EB3. This is because there is a demand. There is availability of visa numbers. There's not as much demand as there was expected to be, which is the same as last year, and it's the same reason as last year. The consulates have not really opened up completely, so they are not processing cases, and therefore they are not asking for visa numbers. And so there are a lot of unused visa numbers remaining, and that's why we are seeing a rapid forward movement of EB3 and EB2 for India and China. And we're likely to see, as per Charlie, further forward movement in the coming months of summer and in fall as well.
Okay.
So that's a very important update to keep in mind. So another important update is that for EB3, most probably the final action date will be 2012 or 2013 in the near future. So very soon it'll be 2013 for EB3. So all those who are wondering, within this year, most probably the final action date should go into 2013, if not 2013, if not 2012, then at least close to that, close to 2013. And all this is happening because, as I said, all those family-based petitions that have been filed worldwide, the consulates are not processing and they're not using up visa numbers. So because of that spillover, we have 290,000 employment-based visa numbers available, which have to be used up, right?
Okay.
So this is why we're, having this rapid movement. So if you've noticed in this June Visa Bulletin, there are two dates, right? The dates for filing and final action date. So the dates for filing also have moved forward. And some people might be wondering, what is the purpose of moving forward those dates? Because you anyway cannot file based on those dates unless USCIS says you can. So USCIS has continued to say that you can only use dates for filing throughout this year. So what's the purpose of moving that other table forward? So Charlie says that the reason he's moving that forward is so that, especially for people outside the country, for the consulates, when they see those dates moving, and if that dates for filing become current, then they start asking for whatever missing documents. That's when they start asking for those documents from the applicants. So if a birth certificate was not there, medical, police record, something is needed, that's when they start. They don't want to start asking before that because they don't know when it will become current, and they want, most updated documents. So that's when they start. So by processing it, and then they can maybe request for a visa number if it becomes available. So it's easier for the Department of State to decide then how much demand is there. That's the reason he gave us for why those dates for filing have to be moved up as well.
So today we are discussing on I485 and Visa Bulletin FAQs. So yeah, Prashanthi, do you wanted to add more on the Charlie's updates, or shall we proceed with further questions?
No, we haven't come to the actual meat of it, and I'm just, keeping people in suspense. But so yeah, so dates for filing in the big news and expected news maybe is dates for filing will be used in the month of October, as it was done last October. And we can expect forward movement in those dates. We've already seen forward movement in dates for filing in the June Visa Bulletin, and I think we'll see further forward movement. Then there was a question about, so when there's so many of these numbers available, how are they allocated? Can they just be allocated to India? It was someone's question. And basically, no, it doesn't work like that. What happens is that I think 28.6% of the numbers that are available will be used for EB cases, EB 1, 2, and 3, right? And the remaining then are used for the other categories. And out of that, only 7% are used for each country. So if there's a country that doesn't require it, then of course, then again, they use the same formula and continue to process the spillover cases in the same way. So ultimately, yes, the people who get benefited the most are the people who've been waiting the longest. The visa numbers will go to them first. And that's obviously India EB3 cases. And that's what we're seeing. But it doesn't just automatically spill over to them. There's a formula in place that they use. So yeah, as we said earlier, we're expecting that in October, EB3 2013 final action date will become current. So that's a big update that Charlie gave us. Also, he said that whatever the filing dates are right now in the June Visa Bulletin, those filing dates are likely to become final action dates by the month of September. So that's a good indication of where the final action dates will be, in the October Visa Bulletin. That's the start of the, end of the old fiscal year when they have to use up all the numbers. That's why we see in October there is, maximum forward movement because they have to use up the numbers, before the new visa fiscal year starts. So that's the update. So 290,000 available. Maybe the dates for filing will go into 2016 or 2017 for EB3. Difficult to say, but based on the numbers available last year and the way the cases moved forward last year by 3 or 4 years, if we apply the same, logic, it might happen this year as well. So those of you who are in 2016, 2017 or earlier, there's no harm in keeping your, documents ready. So that's another big news. But of course, this is only speculation. Now, some people have asked, okay, all this is moving forward, but will it retrogress? So Charlie said that it will not retrogress for this year and it will not retrogress next year also. But after that, towards the end of the next fiscal year, there'll be some retrogression as the consulates open up and the demand becomes more and they start using up visa numbers. Then, you might not have this, availability of visa numbers as you have now. So you can't be sure that the next October also the same thing will happen because, by then everyone is expecting that things will, return back to normal because this is a unique situation because of COVID-19. The demand is not that high because of, that reason. So you can expect things to go back to normal, which is not much movement. But as of now, there will be a lot of movement. So I think everyone should take advantage if their visa number becomes available and keep all their documentation ready. So I think that's my update for, the Visa Bulletin.
Yeah. Thanks for the updates, Prashant. I think there are a lot of updates that Charlie has provided us this week. Coming to this AC21 job portability. So do we have anything on that?
AC21 job portability basically is, if you file a 485, there's no change in it, but the law basically says that if you file a 485 and the I140 is approved and 6 months has passed since the date of the filing of the 485. So two things: approval of I140, 6 months passage from the date of 485 filing. If those two conditions are met, then you can change employers by filing this 485J supplement. Earlier, there was no form to file. We just had to inform them that, this is the new employer, submit a letter from the new employer and show them how the job is similar. So that's another requirement, that the job has to be same or similar. So as long as these conditions are met, that AC21 portability is possible. So you don't have to be stuck with the same employer, when it's taking so many years sometimes for your priority dates to become current.
Okay. So like you mentioned, filing supplement I485J. So what is needed for filing it?
For filing of the 485J, it's a form that requires some information in it. So that information is required from the employer. Basically, the information is the job title, present job title, salary, start date, end date of the employment, and the duties. So this is the information, and then biographic information of the beneficiary, the alien applicant as well, date of birth, address, name, etc. And most importantly, it has to be signed, that form, by both the employer as well as by the applicant. So, and what needs to be carefully looked at is if those job duties that have been given. So oftentimes, the green card would have been done like a few years ago. And by the time you file the 485, it's quite possible that the job might have changed, or you've received a promotion, there's been a salary hike. So that's why they've said in the AC21 regulation that the job doesn't have to be the same, or it needs to be similar, and they've not really provided a definition of what similar is. So the way I do it is, if it's any IT related position, for example, you were working as a systems analyst previously and now you're working as a software engineer, I would say it's similar. But for example, you're working as a systems analyst earlier and now you're working as a financial analyst, I would say that is not similar. Of course, it's not so clear cut sometimes, and sometimes you really have to go into the duties to see whether it's similar or not. And present your best case before USCIS for them to decide. So this is basically the job description is important, and you need that 485J to be signed by the employer.
Okay. So Prashanthi, we have a caller, Rajiv from Chicago. Hi, Rajiv.
Hi, Prashanthi ma'am, I have a question.
Yes.
So actually, my aunt, she is actually U.S. citizen, and her brother's wife actually is planning to come to U.S. So initially, she was the one who sponsored them the visa. So with the travel ban now, can she come, because like the brother's wife can come using that visa because it is a U.S. citizen that is sponsoring, or will it be still the ban will be effective?
So what visa is it? The immigrant visa that is approved? Has that been approved?
That is normal, the visitor visa.
No, there is a ban for visitors visa, and you don't need a citizen to sponsor you for a visitors visa. Really, anyone can sponsor. So I was thinking that she filed a green card for them, and their green card is approved, and you're asking whether they can come on the immigrant petition. So on a visitor's visa, there is a ban, so no one can come right now until the ban is lifted.
Okay.
Okay, even with the citizen sponsoring it.
It really doesn't matter who sponsors it. It's a B2 visa, and there's a ban on B2
Yeah.
visas.
Okay. Okay, got it. Thank you.
There are some exceptions, but this doesn't fall under the exception.
Okay. Thank you for calling us. And coming to our topic, so after a person gets a green card, is it legal to work in two companies? I mean, not the original company simultaneously?
So once you get a green card, you can work for anyone. But it might be a good idea to work for your petitioning company at least for 6 months after you get your green card.
Okay.
Simultaneously, you can work for another company as long as you work for your petitioning company also. And the reason I'm saying it's a good idea to work for your petitioning company after you get your green card is it might be easier for you when you file for citizenship. Because they usually look to see in the citizenship application whether you ever worked for your GC employer, after getting the green card. So that, might not be a bad idea to, in order to make it easier, if you can, to work for your petitioning company after, at least for 6 months after you get the green card.
Okay. We have one more caller, Shekhar from. Hi, Shekhar.
Yeah, hi. Good evening. Yeah. Well, I have a question on Sorry. Hey, can I go ahead?
Yeah, please go ahead.
Well, see, I have a question on I140 and H1B extension after that. So, is it possible to file both I140 and on H1B extension combined, or do we need to wait till I140 get approved and then only allowed to file an H1B extension?
So you can get extension beyond 6 years in two ways, right? One is if your labor has been pending or approved more than 365 days ago. Another way is, then you get only 1 year of extension. Another way is after I-140 approval. So you have to see which one you qualify for or which one you want to use. You might want to use the I-140 approval one by filing your I-140 in premium processing if you have time, and then filing your H1. So it's one of the two that you can use. So you have to see which one whether if you qualify for both, then you should obviously use the I-140 approval. If you don't qualify, then if you can wait, then it might make more sense to do the H1 after you get the I-140 approval, because that way you'll get 3 years as opposed to just 1 year.
Okay. Well, I think I follow the second category because my firm is filed within the 365 days. So I need to wait till this I-140 get approved and then file for the H1B extension. Is that correct?
That is correct. So file for premium processing, file it in premium processing, so you'll get it faster.
Oh, okay. Gotcha. Okay. Thanks, ma'am. Thank you.
You're welcome.
So coming back to our topic, Prashanthi, so if a person gets laid off before getting green card, so what happens to his I-485? It's still pending.
Yeah, so if he gets laid off before getting the green card, he should make use of AC21, the process that we discussed earlier, and find a new employer and file that 485J application. Because at any given point of time, now getting laid off by itself is not an issue if it's a temporary layoff.
Okay.
But there has to be an offer of permanent employment attached to that 485 at any given point of time. Because a 485 cannot exist without an offer of permanent employment from a qualified employer, a qualified job. So, for example, if you're laid off, your employer says we're laying you off for 2 months and you can join back after 2 months. That is not really an issue because that offer of permanent employment has not been withdrawn. But if the layoff is permanent, then you should look for another employer to fill out that 485J application and send it out. So that's important. I mean, you don't have to join that employer immediately. At some point you do, but it's not like what is important is they send the 485J not the actual joining. The joining can take place later.
Okay. So what happens if a person driving under the influence? If a person is driving under the influence, and what happens to his I485 approval? Will it get rejected?
Right. So this is applicable for all these petty offenses. Well, I mean, a lot of people have questions on DUI because that's most
Common.
common thing that happens. But so it depends on what the incident was, right? So if you had a DUI and you just got a ticket because I mean, they found out that you were under the influence, but since you, if you did not hurt anyone or nothing else happened, if you were not, in an accident or behaving negligently or violently or etc., then it could be that they just have a ticket, and then that will not affect your 485 application at all. Now, it could be that you were drinking and driving and then you got into an accident and someone got hurt. In that case, then it might be they might arrest you and charge you with a misdemeanor. So if they charge you with a misdemeanor, it's still not an issue because your attorney should be able to argue that it falls under the petty offense exception. So certain offenses which involve jail time of less than a year or fines of less than certain amount of money come under the petty offense exception. So that's possible. So that's one thing. But the same DUI, suppose you were stopped and then you got into a fight with the officer and there's assault, or you get into a fight with another passerby person, another person who maybe you hit or maybe hit you, then it's a case of assault. That can escalate further, and then it may not be under the petty offense exception anymore. Then it could be a felony. In which case, then you will have issues with your 485 unless you fall again under one of the exceptions. So it really depends on what the nature of the offense was. But traffic violation, for example, you were speeding and you got a speeding ticket, that doesn't affect your ability to get a 485. But there's another thing, Priya, called crimes against moral turpitude. It's a very vague term. But basically, it has nothing to do with whether it was a misdemeanor, whether it was a felony, but they're looking at whether you did something immoral, So if they think, and they've given this very detailed definitions of what this crime is. So it could be that you have a crime that falls under that category, but may not actually be a felony. So in that situation also, it could be a problem. So there's documentation that has to be submitted. Maybe it's better you wait until the sentence has been, your probation period is over, and you show that you've completed the probation without getting into any further trouble. You submit affidavits from your friends, employer, family members showing you're a good citizen and of good moral character. So there are ways of overcoming that also.
Okay. So we have another caller, Kiran from California. Hi, Kiran. Hello.
Hello, madam. How are you doing, madam? How are you doing, madam? Hello. This is Kiran here,
Yes,
ma'am.
sir. Yes. Go ahead, Kiran.
Yeah. How are you doing? Yeah. Thanks for giving us the our queries actually. So, my friend got EAD approved, and she got EAD first time, and today they received the EAD card, but they did not receive the SSN number. So, what is the process of getting the SSN number, ma'am?
They have to go to the Social Security office and show the EAD card and apply for the SSN. Usually takes a few weeks to get the Social Security number. So that will be issued by Social Security office, not by immigration.
No, they applied in the application itself to get the SSN number also when they are applying
No, but that
the
doesn't work
application
like
form.
that. Yeah, I understand, but they will notify the Social Security office. But you do have to go to the Social Security
Mm-hmm.
office and apply for SSN based on your
Okay.
EAD card.
Okay. When today morning when my friend called to Social Security office, they said like from Homeland Security you are going to receive your SSN card, SSN number, like that they told it seems actually when you call to Social Security office.
Hmm. As far as my knowledge goes, you have to actually go and apply for the Social Security card and
And
SSN number
moreover, they
at
told
the
like office is closed. It seems it's
right.
due
That
to
is
COVID.
possible. Yeah. It's possible that the offices may be
Hmm.
closed, but most probably they'll be reopened, right? Maybe closed for Memorial. Or is it closed because of COVID?
No, because of COVID, they are closed. It seems they told it seems office is closed.
So there is another way. You can apply at any office. It doesn't have to be that particular office. There may be other offices that are open.
No, okay.
So you
Okay.
can apply in any
So it
office
will
that is
not
open.
it will not come through USCIS directly from the Homeland Security onwards.
Not to my knowledge, but I can check on that for you.
Oh,
Send me an email offline. I will check on it. But to my knowledge, these are two different
okay.
departments, and so the Social Security card is issued by the Social Security office. But I will check on that for you.
Yeah, yeah, please, ma'am. Okay. Yeah. Thanks for
Yeah,
thank you, ma'am.
yeah. Thank you for calling us. And if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readyesq.com or call 212-354-1010 or visit www.readyesq.com. Prashanthi, can a person work on? Can a person not work even still stay in USA if he has a EAD card?
Right. So then the question arrives. Yes, that they don't need to work depending on the situation. So, for example, if you're on H4 EAD, you don't have to work. There's no compulsion that you have to work. You can work at will. If you're on L2 EAD, it's up to you whether you want to work or not. But if you're on F1 OPT, then there is a requirement, right, that you work for a certain amount of time, depending on whether it's STEM or if it's the original 1 year OPT. So for a 485, since our topic is 485, so for a 485 EAD, you don't have to work, but then the question comes whether you have that offer of employment or not. So if you have an offer of employment, but you're not actually working for that employer, USCIS might say, what's stopping you from working for the employer? You have an EAD, you're allowed to work. How do we know that you'll actually work for the employer after you get the green card? Because it is a future offer of future employment. The whole concept is that once they get the green card, they will work for them. That's why they're petitioning. But often officers will ask, why are you not working now? What's stopping you? So you have to have a legitimate explanation of why you're not working, and that could lead to some suspicion on the part of USCIS that maybe the job offer is not a bona fide offer of employment.
Okay. So what is this H1B denial effect on I485?
So a lot of people choose to maintain their H1 while having a 485 pending because they don't want to give up their non-immigrant status. And this is for various reasons. Maybe they're worried that if the 485 gets denied, then they'll fall out of status. Then they have to leave the country, then come back on a fresh H1, so they want to avoid that. Others might worry about the aging out. So children aging out. If the child ages out of a 485 and you're on 485, the child immediately falls out of status and then has to leave the country. They cannot file for a change of status from a 485 to some other status. But if the child is on a H4, then before they age out, without leaving the country, they can file, for example, a change of status to an F1. Most probably they would be going to school anyway. So that's why some people keep both statuses, simultaneously. So if the H1 gets denied, you don't have to leave the country, because remember, you have the 485 status, which allows you to stay in the country.
Okay.
But then if you want to work, then you have to use the EAD. And once you use the EAD, then of course, then you have changing your status from a H1 to a 485 EAD. And in order to change back to a H1, you have to leave the country, come back on a fresh H1 visa.
Mhm.
You cannot file a change of status from 485 to H1 while staying in the country.
Mhm. So like you mentioned on the age out, so can you provide more information on this age out or CSPA for children immigrating to US?
Yeah, so a big issue with Indian nationals is the children aging out, because it's taking 20 plus years for parents to get their green card. So obviously in the interim, the child will age out, because, if you're over 21, then you don't get the green card with your parents. So it depends. Now, if the 485 is filed for the child as well, that doesn't protect them from aging out if you use the dates for filing and filed a 485. Remember, there are two dates. Dates for filing is this artificial date that the Department of State has come up with, which allows you to pre-file, but your date is not actually available. Dates for filing is the actual final date, when your date is actually available. When if you file, you will get the green card as soon as it's processed. So there's no waiting time. So if you file your case based on final action date, and then your child ages out after you file the 485, it's fine. The child is protected under CSPA.
Okay.
But if you file based on dates for filing and the child ages out, then the child is not protected. So that's something to keep in mind. So the other thing that CSPA says is that whatever time it took for your I-130, your immigrant petition, to get approved, that is your I-130 or I-140 to get approved, that time can be deducted from the age of the child when deciding whether the child is aging out or not. So if the child is 22, if the I-140 took 1 year or 2 years, then you can deduct that from 22, then the child will be 20.
Mm-hmm.
So then at that point, you can, if you haven't filed the 485, you can file the 485 for the child. If the child is going to get the green card, they will get it, even though they have gone beyond 21. And you filed under dates for filing. Because there's an artificial formula which they use to reduce the child's age. So those are the elements of CSPA.
Okay. Can you provide more details on I-485 or AOS filed maintaining H1B status after getting EAD or changing jobs? Can you provide more information on this?
Right. So I guess what you're asking is how to maintain a H1 when your 485 is filed, what to do or not to do.
Yes. Yeah, like when changing the jobs and getting EAD and all.
Right. So if you're on a H1, then you continue as if you're on a H1. So you would, every time you filed, if you want to maintain your H1, every time you changed employers, you would have to file a transfer. Every time you changed work locations, you'll have to file an amendment. If you leave the country, you'll come back on a H1 visa, but you'll still be able to maintain your 485. That's important. There is a question, though, some people ask about this, which is if they leave the country and they come back on advance parole, instead of coming back on a H1, then are they still considered to be on H1 status? This is $1 million question. A lot of people ask this question. And the answer is tricky, but I think it's well established. And there's no black and white answer for it. But basically what USCIS has said is that if you come back on advance parole, and then if you file an extension on your H1, the USCIS should approve that extension or amendment or whatever it might be, transfer. If you file, USCIS should treat you as if you are on H1 and extend or approve that petition if it is approvable. Which means basically that USCIS is allowing you to come back on advance parole and then continue to extend your H1 or work on your H1. That's what it means. So that's what they have said. They have not clearly answered whether you can or not, but they have said about filing extensions or transfers that you can do that. So that's important to note. Another important thing is that if you are on a 485 and you have a H1, and for example, if your H1 gets denied, as previously we were discussing, and you don't want to leave the country, and because you have a job and leaving the country and then getting a visa, coming back in, filing a new H1 takes time, you decide to switch to an EAD. So if you switch to an EAD at this point, then you will no longer be on H1. So when you travel on advance parole, it's possible to continue to be on H1. But if you switch and start working on EAD, it's not possible to continue on a H1. Then you will be on a pending 485 status. Then, if you want to be on a H1, then you have to leave the country and come back on a H1 visa.
Okay. So like you mentioned this about advance parole. So what is this advance parole and why is it needed?
So for advance parole, basically, 485 can be filed based on employment, based on family-based petitions, right? So other than employment, any other 485 that you file, if you leave the country and if you do not have an advance parole application approved and you come back on another status and not on advance parole, your 485 is considered to be abandoned. Very important. So you cannot travel without an advance parole. But there is an exception, as we discussed, for the H1. For the work visas, employment-based visas, L1, H1. So advance parole is a document that allows you to be paroled in without a visa into the United States based on the fact that you have a pending 485. So you don't require a visa to come into the country if you have an advance parole. So that's the advantage of advance parole, and usually they give it 1 year at a time, unfortunately. So every year you have to apply. And usually it takes, it's been only taking 1 to 3 months, but because of COVID, it's taking much longer now. So you might find yourself in a perpetual stage of applying for advance parole every year. So that's something that, is not really that practical, but that's what the state of affairs is.
Okay. So can a person change a job after I140 approval and before I485 submission? Can he change the job?
If he changes the job after the I140 approval, then there is AC21 cannot be used for the purposes of filing the 485.
Okay.
So he cannot use that I140 and file the 485 through another employer. But he can use that I140 to maintain the priority date for his next I140 that he's going to file through his new employer. And he can use that I140 as per AC21 for filing further extensions on his H1. So for some purposes, he can use it, but for the most important purpose of filing a green card, he cannot use it, he or she. Therefore, they have to file for a new labor and then put the priority date on the new I140 and go that way with the new employer. Follow that process.
Okay. So this is regarding this EB2, EB3 portability upgrading and downgrading. So what is the eligibility for and the process for EB3 to EB2 porting? Right.
So that's also a thing that a lot of people are doing now because of these EB3 rapid forward movement, but there's also EB2 movement. So people don't know, are confused as to whether they should downgrade or just keep it as is, and maybe EB2 will become, final action dates will become current. So there's a lot of confusion on that. And my suggestion has been that if you want to do it, and if your employer is willing, and if you think it's approvable, and there's no ability to pay issue, then you should file a new I-140 for EB3 and keep it. So then now you have an I-140 for EB2, you have an I-140 for EB3, you can use whichever one you want to. So then there is at least no anxiety on having one and not having the other. But of course, the problem is sometimes employers are not willing to do that, or sometimes, ability to pay is not there, which means that the employer is not able to show that they have the ability to pay you the prevailing wage. And they have to show that it might have been approved earlier, but maybe the employer's financial situation has changed now, or maybe your salary has changed now this year. So when you try to file it again, maybe that you no longer have that ability to pay and it may not get approved. So that's something to keep in mind. But it doesn't in any way affect your already existing I-140. So
Okay.
there's no harm in doing that. But filing an amendment may not be a good idea, because then you're losing your previous date.
Okay. So what is this I-485 adjustment status? Like, what is that?
So this is what we're talking about, right? Filing a 485 to get the green card. That is the last step
Okay.
in the green card process. So the first step is, in most cases, is the labor cert. In some cases, labor cert is not required. The second step is the I-140, which is the filing of the immigrant petition. So in the labor cert, you're testing the market to see, and you're placing advertisements, and you're saying you're trying to find a US citizen or permanent resident to fit the job, and you couldn't find anyone, and therefore you're filing. So this is filed with the Labor Department. The next step is the I-140, the immigrant petition, where you are filing with USCIS, and we are showing documentation proving that everything that you said in the labor cert is correct. You provide the actual documents, you show ability to pay as we discussed, you show that you have the experience and the education that was required in the labor cert. And once the I-140 is approved, you file this adjustment of status, which is called the 485. In the 485, you have to submit documentary evidence of qualification. So basically biometrics, medical records, and your birth certificate to show that it's you, your passport, proof that you are in status. All these documents have to be provided when you file a 485. That's a premise for a 485 basically. And then fingerprints will be taken. Security checks will be done before you get the green card. They will make sure that you have the affidavit of support may be required if you don't have the income yourself in family-based cases. So these are the things that they look at in a 485.
Okay. So today we discussed about the Visa Bulletin. So where exactly we can find this Visa Bulletin? Is there any site?
Yeah, so you go to travel.state.gov and then under that you will find the Visa Bulletin. Or you can just Google Visa Bulletin, and whichever month you want to Google for June, you say Visa Bulletin June, and it comes up. That website will come up for you. And the way to look at it is look at your category, and if it's employment based, if you're EB3, look for EB3. Most often you have to look for dates for final action date, because dates for filing are not usually looked at except in October of every year. So you have to look at final action date, see if your date is current, it has reached your date. If it has reached your date, you can file the 485.
Okay. So like how often or when does this Visa Bulletin gets updated?
So the Visa Bulletin gets updated every month. So the 15th of the previous month. So for example, the June Visa Bulletin, we got it, I believe, May 15th or a little later. So usually you get it by the second week or the third week of the previous month, the Visa Bulletin for the next month. But sometimes there's a delay in the Visa Bulletin if there is some issue and they're not able to decide what the date should be because there's some confusion on the demand and the supply, etc. They delay the issuing of the Visa Bulletin. For example, in October, they delayed the Visa Bulletin issuance until almost the last day. So we had to rush and file all the cases in October. But it turned out that November Visa Bulletin was also current. So if we had known that earlier, then there wouldn't have been such a rush, to file all cases within that short period of time. And then what happened is a lot of cases were not filed properly because of lack of time, and a lot of cases came back. If you look at what's being said in the market, but 10 and what's being said by USCIS, 10% of the cases came back for some reason or the other, because basically it was rushed. So I think you have to give advance notice, in order for us to be able to prepare and for the applicant to prepare and file the 485.
Yeah. Thank you so much, Prashanthi. And viewers, if you have more questions and would like to reach out to Prashanthi, you can email at prashanthi@readyesq.com or call 212-354-1010 or visit www.readyesq.com. So we will be back with next week with more interesting topics on immigration. This is Priya Goteti signing off. You are watching Sakshi Manasakshi. Thank you.
Thank you.